Good afternoon. It gives me great pleasure to speak today on professional misconduct, medical negligence, and manslaughter by gross negligence. Before I start, can I clarify one thing? The nameplate in front of me gives me the title doctor. It's very kind of the organizers to give me that title, but I'm not a doctor, I'm a lawyer. When does an act or omission of a doctor amount to medical negligence, or in addition, professional misconduct, or if it causes death, even the serious criminal offense of manslaughter? Today I'll revisit with you these three concepts. First, what is medical negligence? As you may be aware, the basic test is the Bolam test. It's called Bolam because it was first propounded in a case called Bolam. The Bolam test comprises two principles. One, the standard that a doctor has to meet is the standard of the ordinary skilled doctor exercising that skill. Two, a doctor is not negligent if he or she has acted in accordance with a practice accepted as proper by a responsible body of medical opinion. 2 points arise from the first principle of the Bolam test, the standard of the ordinary skilled doctor exercising that skill. First, the standard required is not the highest standard, but ordinary skill. Second, although the standard required is the ordinary skill, a specialist must exercise the ordinary skill of a specialist and not the ordinary skill of a non-specialist. The second principle of the Bolam test refers to acting in accordance with a practice, not the practice. What this means is that where there are more than one accepted practice, a doctor is not negligent if he or she acts in accordance with one accepted practice, even if there is another accepted practice which takes a contrary view. There are, however, a gloss on the Bolam test, an exception to it. The gloss is that acting in accordance with an accepted practice is not an absolute protection. An accepted practice must be capable of withstanding scrutiny and logical analysis. If an accepted practice cannot withstand scrutiny and logical analysis, then even if a doctor has acted in accordance with it, the doctor may still be held negligent. This follows a case called Bolitho. The exception to the Bolam test, as you probably are now well aware, is in relation to informed consent. Now, before this exception was introduced, the Bolam test was applicable to all aspects of a doctor's medical management of a patient, from history taking, examination, diagnosis, obtaining informed consent, treatment, and post-treatment care. Now, with regard to informed consent, applying the Bolam test means that if, according to an accepted practice, a risk of a proposed treatment need not be warned to the patient, then the doctor was not negligent in not warning the patient of such a risk in obtaining the patient's consent to the treatment. However, in March 2015, as you now know, the legal principles governing informed consent were changed in the case of Montgomery. It would be useful to go through again the new principles introduced by the Montgomery case. First, what risks of a medical treatment to inform and explain to the patient does not depend on accepted practices of doctors. A doctor is under a duty to take reasonable care to ensure the patient is aware of any material risk involved in any recommended treatment and any reasonable alternative or variant treatments. What risk is material? The test of whether a risk is material is whether a reasonable person in the patient's position would be likely to attach a significance to that risk, or the doctor is or should reasonably be aware the particular patient would likely attach significance to that risk. Whether a risk is material cannot be assessed only according to the likelihood in percentage. the significance of a given risk is likely to reflect a variety of factors, including the nature of the risk, the effect its occurrence would have on the patient, the importance to the patient of the benefits of the treatment, the alternatives available, and risks in those alternatives. The assessment of whether a risk is material is therefore fact-sensitive, and sensitive also to the characteristics of the patient. The doctor's role is to ensure that the patient understands the seriousness of his or her condition, the benefits and risks of the proposed treatment, and any reasonable alternatives, so that the patient can make an informed decision. This role will only be performed effectively if the information provided is comprehensive. So a doctor's duty is not fulfilled by bombarding the patient with technical information which the patient cannot reasonably be expected to understand, or simply routinely having the patient's signature on a consent form. The doctor is, however, entitled to withhold from the patient information as to the risk if he reasonably considers that disclosure of that risk would be seriously harmful to the patient's health. In a nutshell, the new principles under Montgomery are that what risks of a medical treatment a doctor must inform and explain to a patient have to be tailor-made for the patient. And the illustration is a situation in which a medical treatment is proposed for one eye of a patient. The proposed treatment carries a very small risk of causing blindness to the eye to be treated. This very small risk is of little significance if the patient's other eye is perfectly good. This very small risk may be of much more or even great significance if the patient's other eye is already blind. So in the latter situation, in warning the patient of the risk of the treatment, the doctor must have regard to the particular circumstance of the patient that his other eye is already blind. In Hong Kong, there's one situation of informed consent in which the Bolam test may still be applicable, rather than the new principles propounded in the Montgomery case. This is the birth trauma situation. Now, Montgomery is itself a birth trauma case, but Montgomery is a decision of a United Kingdom Supreme Court on an appeal from Scotland. In Hong Kong, there is legislation which has the effect of retaining the Bolam test with regard to informed consent in a birth trauma case. In the birth trauma case, it is necessary to first explain the right to claim for compensation. Obtaining informed consent regarding the mode of delivery took place before the birth of the baby. With regard to informed consent, the duty of care was owed by the obstetrician to the mother, and not the baby in the womb, because while in the womb, the baby has no legal status. However, it's the baby who suffers from birth trauma and who claims. So there is a mismatch between the person to whom the duty of care was owed and the person who suffers injuries as a result of breach of that duty of care. The legislation stepped in to give the child born disabled the right to claim. This is the Law Amendment and Reform Consolidation Ordinance, which I shall call by the acronym LACO. Section 22B of LACO gives the right to claim to a child born disabled if the disability resulted from an occurrence before birth which affected the mother during her pregnancy, or affected the mother or the child in the course of birth, so that the child is born with disabilities which would not otherwise have been present. So on the issue of informed consent in a birth trauma case, in Hong Kong, it is the Bolam test and not the principles propounded in the Montgomery case that is applicable. I mentioned that the Montgomery principles on informed consent are an exception to the Bolam test. What this means is that, and it's important to bear in mind, on the question of medical negligence, with the exception of informed consent, the Bolam test is still applicable to all other aspects of a doctor's medical management of a patient. Medical negligence itself is not something illegal as such. The significance of medical negligence itself is that it gives the victim a civil claim for compensation. As to whether the doctor's act or omission, which amounts to medical negligence, can have other consequences, I turn to professional misconduct. What is professional misconduct? The term in the medical registration ordinance is actually misconduct in a professional respect. But for ease of reference, I should continue to call it professional misconduct. The Code of the Professional Conduct of the Medical Council of Hong Kong correctly explains what professional misconduct is. It is as follows. The term misconduct in a professional respect is not defined in the medical registration ordinance, but has been interpreted by the Court of Appeal as conduct falling short of the standards expected among registered medical practitioners. It includes not only conduct involving dishonesty or moral turpitude, but also any act, whether by commission or omission, which has fallen below the standards of conduct which is expected of members of the profession. It also includes any act which is reasonably regarded as disgraceful, dishonorable, or unethical by medical practitioners of good repute and competency. To err is human. We all make mistakes. If a doctor makes a mistake, and such mistake amounts to professional misconduct, medical negligence, does it also amount to professional misconduct? The definition of professional misconduct as conduct falling short of the standards expected among registered medical practitioners can be confused with the test for medical negligence because both refer to the falling short of standards. It is important to bear in mind that, as we have seen from the Boland test, medical negligence is about the standard of skill and care, whereas in the definition of professional misconduct, conduct falling short of the standards expected among registered medical practitioners refers to standard of conduct and not standard of skill. However, if the falling short of the standard of skill is serious, it may become a matter of conduct. So, when is medical negligence also professional misconduct and when it should not be? In two cases, Sin Chung Yin and Dr. Yang Yao Yao Cecilia, the Hong Kong Court of Appeal said that ordinary negligence did not normally suffice to constitute professional misconduct, and what must be shown was an elemental and grievous failure. It is recognized by the Medical Council of Hong Kong that wrong clinical judgment does not necessarily equate to misconduct in the professional respect. In the well-known Lau Mei Kun case, the Medical Council found the pediatrician not guilty of misconduct in the professional respect. Even the Medical Council found that the pediatrician had made a wrong clinical judgment. The Medical Council said, we accept that wrong clinical judgment is not always to be equated with professional misconduct. I hope that in Medical Council inquiries, the distinction between ordinary negligence, ordinary medical negligence, and professional misconduct will always be firmly borne in mind. Lastly, I turn to manslaughter by gross negligence. The recent DR case has drawn attention to the potential criminal liability of doctors when treating their patients. In the DR case, the owner of the beauty chain DR Group and the employee technician were convicted of gross negligence manslaughter in providing a customer with an unconventional health therapy, resulting in her death. The owner and the technician were sentenced to imprisonment of 12 and 10 years, respectively. In what circumstances will medical negligence amount to manslaughter? To prove gross negligence manslaughter, the prosecution must establish 4 elements. 1, the defendant owed the duty of care towards the deceased. 2, the defendant breached that duty of care. 3, the breach of duty by the defendant caused the death of the deceased. And 4, the breach of duty should be characterized as gross negligence and therefore a crime. The 4th element, the breach of duty should be characterized as gross negligence, needs clarification. It's not sufficient that looking at what the defendant did or omitted to do objectively from the point of view of a reasonable man, the defendant was grossly negligent. The prosecution must also prove that the defendant's subjective state of mind was culpable and that the defendant was subjectively aware of an obvious and serious risk of death. Does this subjective element of state of mind of the doctor mean that a doctor can be blindly unaware of an obvious risk and serious risk, provided that he or she is in fact and therefore subjectively unaware of the risk? The answer is that if the risk is so obvious and serious, the jury at the trial may not believe that the doctor was not aware of the risk. Last month, a doctor was prosecuted for alleged gross negligence manslaughter. According to news report, the doctor performed liposuction on a woman at a beauty center. The woman died. It was alleged by the prosecution against the doctor that she was grossly negligent in failing to ensure a properly qualified person was present to administer and monitor sedation, failing to follow proper guidelines on sedation, failing to provide a woman with proper and sufficient monitoring, failing to have sufficient oxygen supply during the liposuction procedure, and failing to give adequate and timely resuscitation to the woman. The case will go to trial, and it remains to be seen whether the doctor will be found guilty of gross negligence manslaughter. I'm running out of time, so very quickly, I mentioned the consequences of medical negligence, professional misconduct, and gross negligence manslaughter. For medical negligence, it's civil claim, monetary compensation. Professional misconduct, the penalty may range from warning letter to removal from the register. Manslaughter for gross negligence, serious offense, the maximum penalty is life imprisonment. So in conclusion, in the medical management of patients, an act or omission of a doctor which does not meet the standard of the ordinary skilled doctor or specialist as the case may be, or not in accordance with a practice accepted as proper by a responsible body of medical opinion, amounts to medical negligence. Depending on the seriousness of the medical negligence, it may also amount to conduct falling short of the standards of conduct expected among doctors, and hence professional misconduct. Where the medical negligence was particularly serious, that is, the doctor's negligence was so bad in all the circumstances as to amount to a criminal act or omission, and it caused the death of the patient, the doctor may be held criminally liable for manslaughter. That concludes my presentation. Thank you very much.